And I know exactly what I wrote and what I ruled. You can't use other crimes or acts to show bad character or propensity. There has to be clear and convincing. But it doesn't negate the fact, just because I didn't use that event, it occurred. And it was with two people there. It was with Mr. Nix and Mrs. Nix. And when I hear today situations and testimony about where the seat was put in the driver's side because Kaylee and Nix did it, not Mrs. Nix, Miss Tracey Nix, the defendant, did it, that's inconsistent with the deposition testimony that Kaylee Nix said. It's also inconsistent with what she wrote in her victim impact statement. Then I listened to her testimony about the juror was sleepy and gave a bottle and immediately fell asleep. And there's a video, and I don't recall seeing that. But I also recall in the trial, they talked about giving the baby a straw and some water in a straw, and that this was a situation where their baby didn't have food and milk. And I went through, and I'm going to come down to this in a minute, but the evidence that comes in, I wasn't there, you weren't there. The only people that were there were Miss Nix, and at the time, we get evidence after the fact, and when we're sitting in the room and we're watching it, it comes in. Like, here's the back seat of the car, evidence 41 that came in. Here's the front seat of the vehicle, 40, where there's wipes and things in a car. And when people go places with kids, they leave objects, the thread on the steering wheel, things in the front seat to remind them where they had a child. And I'm not talking about a child that was there, you had an hour-long, 2-hour-long drive. I'm talking a 7 to 9 minute drive. Here's the exhibit 29. It's the back seat of the car. There's evidence everywhere. Then we see the picture of when Nay and them got there. That's evidence 23. I then have a half-empty thing, a bottle, evidence 35. So I see all of that, and I see all the reminders. And then I remember Kaylee and Nix saying that the Lexus, the red Lexus, was equipped with a red rear occupant alert to alert an adult to a child in the back seat. And I know that these cars, Fords, Lexuses, everything has so much weight in the back seat, beeps go off. And I hear her saying I didn't have that. But then I read the deposition taken of Kaylee and Nix, docket entry 201, October 1, 24. Do you know who put the car seat line, page 32, line 5 to 7? You know who put the car seat into the car that day she picked up Uriel up at the glass shop? I do not. I do know it was her tendency to put the car seat in herself. Okay, Kaylee, answer. She typically, whether I was standing there or not, would pick her up and set her in there. And then I would typically help reach over and strap her in. But her car has sensors, weight sensors, so that, just like my vehicle, whenever I stop and put it in park and turn it off, there's a loud ding that says, check your back seat if there's weight in the seat. And so those are things that I'm aware of that were in a vehicle. So when she put her in there, I did not imagine that I had any other staff assist her in the moment putting her car seat. Did she normally put the car seat behind the passenger or driver's seat? I have her telling me it was in the driver's seat because Kaylee did it, and I have Kaylee saying that it was typically in the driver's seat. And then I have these tendencies and these things that I see that show that there's a baby in the car. And let's not forget that we just left Beefalo Brady's. This child was the apple of everyone's eye there. I've been to the Beefalo Brady's. I've had lunch there. There's a lengthy video. There's a video of the car in the parking lot. At the end of the day, Uriel Schock presented this evidence to me through her testimony, her victim impact statement, and her the deposition. The defense has presented to me the witnesses and the evidence. What I know for a fact is Tracey Nix left Uriel in the car at 2 p.m. for over 3 hours. At no time during the 10,800 seconds that elapsed did she think 1 second about her granddaughter. Uriel Schock was there for 2.5 hours with her that day. And she just saw her 7 to 9 minutes before, and then she goes to the residence 7 to 9 minutes away. This child, like I said earlier, was the apple of everybody's eye. It captivated, entertained the patrons and the people at Beefalo Brady's, much like a 7-month-old does, a year-old does, a 2-year-old, a 3-year-old does. You know what you're doing with them, and in 7 to 9 minutes, by golly, you know where that child is. And anything to the contrary, and any excuse to the contrary, is just that. I heard and saw the body cam footage along with the interrogation room video of Tracey Nix immediately discovering what happened after she has a grandchild passed away. She was distraught. I don't believe there's a lot of remorse in that about her grandchild suffering and death. Rather, I see her more concerned with her community image and the death of the child. I want to leave. I want to go away. I want to do this. I want to do this. I want to do this. And I hear today the evidence in the testimony, and I get a little more remorse on that, but is it truly remorse?
Yes.
Tracey Nix, throughout these proceedings, has contended these acts are involuntary. She couldn't form the requisite intent to commit a crime. Her narrative is that she forgot because of senility or by taking her prescribed mind-altering medications. There's no credible evidence to the court that's persuaded this court to mitigate her sentence as the attorneys have requested. This defendant, like many other defendants facing prison sanctions before, is trying to avoid or lessen a prison sentence once arrested and after a jury finds them guilty. They justify what happened rather than accepting blame and truly evidencing remorse. I have practiced law for 30 years. I've sat on this bench for over 3.5 years. I've met my share of people in the Florida state prison system, the federal system, and I understand that they minimize their conduct and they also don't accept responsibility. And that's how it is. There's a pile of them down at Hardee Correctional that'll tell you the same stories that I heard here today. The ultimate determination of when we do a case, and I excluded the evidence of the experts on the defense side. It's when you look at whether a defendant is competent to proceed. It's my determination in the state court, in a trial court. Under the Dougherty v. State case, 149 Southern 3rd, 672 at 678, the trial court is not bound by the reports or opinion of experts. The defense in this case never afforded nor volunteered Tracey Nix to the state of Florida to have her evaluated by its own experts, so the state of Florida, the citizens of Florida, were denied the right to contest the evaluation and procedures and conclusions of the Tracey Nix retained hired experts. They all say we're here for our time. They don't come. They come in here. They get paid. They give their opinion. They give their opinion. If it's valid for the defense, they testify. If it's not valid for the defense, they don't testify. I heard this man's testimony. In a competency or an insanity case, the state has a right to contest the evaluation procedures and the conclusions of the court-appointed experts. Had she alleged incompetency or not guilty by reason of insanity, the state of Florida, and all guilty of one count of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, but in reality causing death, and not guilty of one count of aggravated manslaughter. I've already gone over what I talked about with the Rule 3.704D9 about the victim injury points. Her score sheet is 44 points. Under Florida law, the maximum sentence I can impose for Tracey Nix is 60 months or 5 years in Florida state prison. For me, as a trial court, to impose a departure sentence is a two-step process under Banks v. State, 732 Southern 2nd, 1065, 1067. First, I must determine whether I can depart. That is, whether a legal basis exists for the departure sentence that has been established by a preponderance of the evidence. Two, even if a valid and supported legal ground exists to permit a departure sentence, the trial court must still determine whether it should depart and whether a departure sentence is the best sentencing option in a given case. Two facts the defense argued in their motion to mitigate. 9, that Tracey cooperated with the state of Florida to resolve the offenses she was charged with on November 1, 2022. The court finds that not to be the case here. Tracey Nix did not cooperate. There's no competent, substantial evidence that the crime she was charged with was resolved as a result of her cooperation. To the contrary, she investigated it, she went to trial, she didn't enter a plea to count 2, and she didn't cooperate with law enforcement or the state prosecutor. The second ground they sought mitigation is 10, which is an unsophisticated, isolated incident. There's 3 elements that must be proven by the defendant when you raise that mitigation, not 1 or 2. Number 1, Tracey Nix has to prove to the court that the offense was committed in an unsophisticated manner. Number 2, it was an isolated incident, and she has shown remorse. All 3 elements have to be proved. You can't prove 1 or 2, all 3. Tracey Nix and her husband had the 17-month Ezra at their home, who died 11 months earlier. That is a fact. That came in every hearing I've been in, and I've heard it today as well. The grandchild, Uriel Schock's tragedy, is not an isolated incident. This is the second. The court watched and heard her interview. I do not believe she's showing remorse. I believe she's showing sorrow. It is impossible for a defendant who refuses to accept responsibility for an offense to show remorse for that offense. Sympathy is not the same as remorse. Sorrow is not the same as remorse. What I look at in the Florida statutes, when I deal with Sentencing under 921.02, subsection 1B. The Criminal Punishment Code's primary purpose is to punish an offender. Rehabilitation is subordinate to the goal of punishment. Subsection C. Penalty imposed shall be commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The court does not find that the defendant's sentencing proposal is the best sentencing option. Rather, Tracey Nix should spend the next 60 months in Florida State Prison with credit for time served. The trial court is guided by the code, the sentencing guidelines, and the express purpose for criminal sanctions under Florida law, and a Florida State Prison sentence of 60 months is the best sentencing option. The court also finds that she knew how she was feeling on November 1. The multiple videos, some with audios that day, and the testimony of her Bible study and many friends unequivocally established her awareness that day she is not competent, nor is she insane. She caused Uriel Schock to suffer an agonizing, prolonged death that was avoidable. The court saw all the evidence in the photos. I want to note the diaper bag that was brought into evidence, Exhibit 36, Exhibit 37, Exhibit 38, Exhibit 39, was the most organized diaper bag I've ever seen in my life. And I heard testimony that the child didn't have food, this, that, and the other thing in the beef O'Brady's, and they fed her through a straw. I note that it was an excellent diaper bag. The bottles, food, medicine, and the items were all in quart bags, Ziploc bags. For witnesses to say or allude that Uriel had no milk, formula, or food is hypocritical and untrue. The court finds such testimony by any such witnesses not credible for sentencing purposes. The defense's recitation of their mitigating factors without confirmation by any unbiased expert, in addition to the deficiencies the court found earlier, also fails to establish by a preponderance of the evidence any mitigation that is to be considered by the court today, nor do they amount to competent, substantial evidence for this or any court to justify a sentence of less than 5 years in Florida State Prison for a term of 5 years in Florida, or 60 months with credit for all time served. A $5,000 fine shall be reduced to a judgment lien. The cost of prosecution and restitution will be reserved for 60 days. Y'all can agree on it, or we'll have another hearing. She will be remanded under the supervision of the Department of Correction until her term of prison ends. Now I'm going to speak to this community. I'm not from here. I'm from Winter Haven, Polk County. This community needs to move past this case and leave Kayla and Drew Schock alone. Let them and their 2 children live in peace. This family has lost 2 children, Ezra Schock and Uriel Schock. The tragedy of this case is undeniable. A baby's life is over way too soon, and a family has been severely impacted in unimaginable ways. Whenever a child dies, this entire community suffers. This community needs to move forward and start the healing process. I have made a final determination here. I'm not putting people on probation to be walking around this community to rehash an issue or something to come up. I have sentenced her to 5 years in Florida State Prison. I want this community to move forward. The legislature defined this felony crime. A fair and impartial jury found Tracey Nix guilty, and I, as the circuit judge for Hardee County, have sentenced her accordingly. Ms. Nix, you have 30 days to appeal the judgment and conviction of this court. If you cannot afford an attorney, one can be appointed for you without cost for appellate purposes. Mr. The state, do you have anything further I need to briefly deal with?
You're under to head off an issue. We'll waive cost of prosecution, so we don't have to have it here.
Okay. Do you want to reserve on restitution? If you don't, you can reserve it, and then you can either agree, disagree, or say, Judge, we're not having it, it'll go away on its own.
Your Honor, we can reserve it, and it'll probably go away on its own.
Okay. Mr. Fletcher, anything further we do?
One thing I have to say as for attorney, May Nix Day, and I think I don't know if she's still here, Alex Amanda Fletcher testified there wasn't any car.
I understand.
Okay, because you said that, I thought you said there was.
You're talking about the car seat?
Obviously, we disagree about the remorse. I'm not going to argue with that. We also have a motion for supersedious bond.
You're absolutely correct. Once you file your notice of appeal, the supersedious bond statute will go into effect. You'll then have a hearing on your motion. But the first event that has to happen is the notice of appeal. Once that's happened, send it to my JA for your information. Ursula Nathy is my current JA. Next week, my new JA will be Julie Cochran. Her email address will be circulated on the website. It'll be J. Cochran. So file your notice of appeal, you can either reiterate the motion you've already done on supersedious bond or file a new one, and then I'll set a hearing time that's commensurate with both of y'all's calendars. Mr. Coleman and my JA will work with you on that, okay? And if you're not going to handle the appeal and you got a public defender, please get your paperwork in sooner rather than later.
Yeah, we have an attorney.
Thank you. Court's adjourned.
All right,
And I'm adjudicating your guilt, okay?